If you've ever taken a dive into the world of estate planning, you've at least heard the term power of attorney, because this document is an important tool within estate planning. It is critical to understand the nuance within specific power of attorney titles. So in this video, we'll discuss the key differences between a durable financial power of attorney and general financial power of attorney. First, what is a power of attorney? This is a document that grants legal authority to one person, known as the agent or attorney in fact, to act on behalf of the other, the principal, when they are unable to do so themselves. The powers granted can be broad or they can be very specific, and they will be outlined in the POA letter along with when the agent's powers go into effect or when they will be revoked. These details are what start leading us to the distinctions between a durable power of attorney and a general power of attorney. So what is a general power of attorney? A general power of attorney typically authorizes the agent to act on behalf of the principal for tasks like authorizing and executing financial transactions, signing legal documents, and more when the principal is unable to. With this type of POA, the state will recognize the agent's role until the principal revokes it, dies, or becomes incapacitated. This is because the principal has power to terminate agency at any time under normal circumstances, and the agent is assumed to always be acting at the principal's direction. Serious illness or cognitive decline would fundamentally change the dynamics of that relationship, so the state revokes agency. What is a durable power of attorney? When a person's life changes with an illness like Alzheimer's, for example, their needs change as well. Their abilities to make sound decisions for their care or for their finances will be impacted. So what happens to this person's assets, their investments, and who will a court appoint to oversee them? This is where and why the durable power of attorney was created. It's a distinction that makes the agent's position durable enough to withstand such life changes. They assume the same authority granted by a general power of attorney and continue, or may begin in some cases, when the principal is too ill to act for themselves. The principal would most likely outline their wishes for the agent ahead of time so that should an illness or death occur later, the agent is still acting at the original direction of the principal. To review some of the basics, a general power of attorney begins when it's written or invoked. A durable power of attorney begins when the principal becomes incompetent, incapacitated, dies, or immediately if the POA declares so. A general power of attorney ends when the principal revokes them, becomes incompetent, or incapacitated. And a durable power of attorney ends when proven that the principal is of sound mind to revoke agency or when the principal dies. We're eForms, the biggest online database of legal documents. We've got even more information about drafting a power of attorney at the link below this video. So click the link and don't forget to subscribe for more estate planning tips.